We're going to break down this interesting but complicated topic a little more with Stephen Heifetz, a partner at the law firm Steptoe Johnson. He explained what this Committee on Foreign Investment in the U.S., or we call it, and you can call it CFIUS, actually does.
They review foreign investments in U.S. companies if those investments result in foreign control, and they define of the U.S. company. And they define control very, very broadly. They're the two primary issues that one has to consider when thinking about whether to notify CFIUS of the transaction is whether it results in foreign control, very broadly defined, not limited to 50% stake in the company. It can be much less and still be considered control, and whether it touches on national security. And they have a very broad notion of national security.
The Sany case, what happened there?
Rare, very rare to have CFIUS litigation, to have a case go to court. In fact, that's the only case that has actually ended up in the courts. It was a case in which the parties closed a transaction without notifying CFIUS, and CFIUS then went and effectively compelled a filing, and CFIUS then recommended that the president order divestment of the assets that had been acquired by the Chinese company. And facing that divestment order, the Chinese investor went to court and got a significant court decision saying that the process for making the decision was a flawed process because the Chinese company had not been given an opportunity to review and rebut the evidence against it.
If I was a Chinese executive and I was interested in buying a U.S. company, I was concerned about CFIUS. This particular case in Sany regarding the constitutionality of the process, as you put it, okay, what precedence does that set?
Well, it's a good thing that foreign investors can take CFIUS to court. That helps with the atmospherics, but it is not likely to be of much applicability for the garden variety cases. Most of the time, in the vast majority of cases, the way to deal with CFIUS is to file before the deal has closed, to alert CFIUS that there is a deal, and then to work out any concerns that CFIUS might have through negotiations. That's the way the vast majority of cases proceed, and again, CFIUS clears almost all cases that come before it.
There has been some discussion that a number of Chinese firms are interested in making a purchase of Starwood Hotels. If that were to happen, that would be the biggest, if not one of the biggest purchases or transactions ever. Does that fall under CFIUS? And if it does, what's going to be reviewed? I mean, it's a vacation and hotel. I mean, there's not much of a national security issue there, is there?
Well, CFIUS would want to consider, for example, whether some of the Starwood facilities are near defense facilities. That was an issue in the Rawls case that you mentioned a short time ago. And there are questions about who stays at particular hotels, whether the acquisition of the chain might present opportunities for espionage, which is frankly, obviously, an issue that both governments are concerned about. So that would be a case that CFIUS would want to review almost surely. But the likelihood that it could be approved in the end is probably high.
The spirit of all these issues is about fairness, that foreign investors should be treated equally when it comes to, in relation to domestic investors. And I guess, does CFIUS meet that requirement of establishing fairness among all investors?
Well, CFIUS, like any other U.S. government enterprise, operates against a background of an open investment policy. So CFIUS, like everybody else, wants foreign direct investment. They want to protect national security at the same time.
Now, I know we focused a lot on China on this for obvious reasons, but some would argue that, well, what about the other countries out there? What about Indonesia, Australia, you name it? Yeah. A couple hundred other countries out there making acquisitions in the U.S., they don't get the type of scrutiny oftentimes that China gets. Is that a fair argument?
No, I think that's not quite accurate because these cases are reviewed. It's case by case. The particulars matter in every case. And there are many companies from other countries that run into just as significant problems with CFIUS as Chinese companies. So it depends on the sensitivity of the assets, the concerns about the threat, and the potential consequences. There are Israeli companies, there are Russian companies, there are French companies that have run, and these are have made it out into public discussion. Companies from all of those countries have run into significant CFIUS problems.